Swayam Prabha. Digital India. Educated India.
Hello everyone, welcome to lecture number 8 of our course on law of copyright, patent, trademark and other IP. This is the last lecture on copyright, and from next session onwards we will be talking about patent law. We have discussed what are the subject matter of copyright, what are the rights granted under the Act, who will own those rights, what are the instances of infringement? When can we say that these rights have been infringed? What are the defenses which the defendant can take once the infringement is proved? And what are the remedies for infringement? We discussed about civil remedies, administrative remedy of section 53, banning the importation of infringing copies. And we also discussed the chapter of offences, particularly the offences which are there in section 63, section 65A and 65B. If you recall, I said 65A and 65B are new entries. These have been incorporated in the Act in 2012. We are trying to make our law compliant with WIPO Internet treaties because the digital agenda of WIPO Internet treaties are an important thing, considering that more and more works are now available in digital format. So this is what we have discussed so far in copyright. I will be talking about 3 different issues in this session. I will devote some time on moral rights, I will devote part of my lecture on copyright societies, and towards the end I will devote some time, few minutes, on the concept of neighbouring rights, and that will conclude our discussion on copyright law. As I said, from next session onwards we will talk about patent law. Now let us see what is there in this presentation. The first point we will discuss is moral rights. I mentioned about moral rights when I was discussing international documents. I referred to Article 6 bis of Berne Convention. Article 6 bis of Berne Convention 1886 provides for moral rights. I referred to moral rights when I was discussing section 14, where we were trying to understand meaning of copyright. We said those rights are economic rights and moral rights are not economic rights. These are different from economic rights. So I have been referring to moral rights. Section 57 of the Act talks about moral rights, but the word used here is author's special rights. We need to understand why do we call these as special rights. What section 57 says? It says independently of author's copyright and even after the assignment either wholly or partially of the said copyright, the author of the work shall have the rights: A, to claim authorship of the work, and B, to restrain or claim damages in respect of any distortion, mutilation, modification or other act in relation to the said work if such distortion, mutilation, modification or other act would be prejudicial to his honour or reputation. So you can see here there are 2 rights. One is to claim authorship. This may be called as paternity right, and the second is to restrain somebody from distorting, mutilating or modifying the work. This can be called as integrity right. Integrity right. So expressly we can see there are 2 moral rights which we have. One is called paternity right and the other is integrity right. You can see section 57 clearly says that these special rights, the moral rights, are independent of copyright. There is no relationship between copyright and moral rights, except that both relate to the same work. There is no relationship between copyright and moral right. And you retain moral right even after the assignment of copyright. So, even if you have assigned your copyright, you still retain your moral rights. An important observation is these moral rights are granted to authors. So, unlike copyright, unlike economic rights which are granted to owners, moral rights are granted to authors, point number one. Second, there is no relationship between moral rights and copyright because the provision says that moral rights are independent of author's copyright. Third, you retain moral rights even after assignment of copyright. And fourth, there are two moral rights which have been recognized. One is called moral right of paternity, the other is called moral right of integrity. As I said, you retain your moral rights even after the assignment. So, therefore, every assignment deed has to be read in the light of moral rights. We will understand this statement later. As I said, these moral rights are based on Article 6 bis of the Berne Convention. I said there are two moral rights, one is called paternity right, the other is integrity right. Paternity right means that my work must be known by my name, my work must be identified by my name. It may also be called as right of identification. It can also be called as right of attribution, attribute my work to me. It also includes right against false attribution. That means others' work must not be known by my name. So, my work must be known by my name and others' work must not be known by my name. Both are part of paternity right. This is called right of attribution or right of identification, and as I said, it also includes right against false attribution. The second right I said is right to integrity of the work. Nobody can mutilate my work, distort my work to an extent that it harms my reputation. The provision was amended in 1994. Prior to the amendment, the requirement of harm to the reputation was not there in this provision. So, any mutilation was actionable, any distortion was actionable. But now only that mutilation, that distortion of my work is actionable, which has the potential to harm my reputation. An important point here is that these rights are contained in the chapter of civil remedies. Section 57 is in the chapter of civil remedies. So, one may get confused as to whether section 57 provides rights or does it provide remedies. Now, what I wanted to convey here is, if you look into the provisions, the first right is right to claim paternity. How will this right be breached? If somebody else will write his name in place of my name, that would mean breach of paternity right. Now, this breach of paternity right can be remedied by providing the remedy, and the remedy is right to claim authorship. So, the statement which you have in section 57, the first right, is both right as well as remedy. Right is to claim authorship and the remedy is to claim authorship. So, remedy for this right is enforcement of this right. Whereas, in case of second right, the integrity right, you can see the remedies are injunction and damages, because the provision says that I can restrain or claim damages in respect of any mutilation or distortion done by somebody. So, there are two remedies identified with respect to violation of second right, integrity right. These are, I can restrain, that means injunction, and I can claim damages. But with respect to right of paternity, there is only one remedy, and that remedy is enforcement of that right. So, what I am trying to tell you is that section 57, although it falls in the chapter of civil remedies, it is both the right as well as remedy. So, one may conclude that section 57 therefore is the complete code on moral rights. You get everything, the right as well as remedy here. Another point is duration of moral rights. So, what all I mentioned about moral rights, I said there are two moral rights, paternity, integrity. Paternity right is also called right of attribution. It also includes right against false attribution. There is no relationship between moral rights and copyright, because the provision says independently of copyright, authors will have moral right. You retain moral right even after assignment of copyright. And because the provision is in the civil remedies chapter, one may get confused whether these provide remedies or rights. So, I clarified that 57 is the complete code, it provides rights as well as remedies. The remedy for breach of paternity right is enforcement of paternity right, and remedy for breach of integrity right is injunction and damages. Coming to another question of duration of moral rights. Paternity right has always been perpetual. The term of copyright on works by Gurudev Rabindranath Tagore has expired. So, therefore, anybody can publish compilation of poems written by Rabindranath Tagore without paying royalty to the legal heirs of Tagore, but I cannot write my name in the compilation. I have to attribute these poems to the author. So, moral right of paternity is a perpetual right, and it has always been perpetual. Whereas, moral right of integrity prior to 2012 amendment was not perpetual right. The provision said that you can claim injunction, you can claim damages for any mutilation, any distortion done to your work which harms your reputation if it is done during the subsistence of copyright. So, you can claim remedy only as long as the copyright duration is going on. But that part has been dropped, and because in 2012 amendment the portion which says that moral right of integrity is coterminous with copyright, that has been dropped, meaning thereby even moral right of integrity has become perpetual. So, duration of protection of moral rights, these are perpetual rights, and this has nothing to do with the duration of copyright. There are few cases which have been decided on moral rights. The first case on the subject of moral rights was decided by Delhi High Court in the year 1987. This is the judgment of Srimati Mannu Bhandari versus Kala Vikas Pictures Private Limited. And in this case, the Delhi High Court says that section 57, this is an important observation, section 57 lifts the author's status beyond material gains of copyright and gives it a special status. Delhi High Court observed that section 57 lifts the author's status beyond material gains. See, there are two remedies which I mentioned for violation of integrity right. One is injunction, the other is damages. There is no provision for accounts of profit because it is not a matter of economic gain. And therefore, court says this section gives special status to authors. I said section 57 does not use the word moral rights. It says these are authors' special rights, and I said we need to understand why do we call these rights as special rights. I get the answer in the judgment of Mannu Bhandari, where the Delhi High Court says that these are the rights which lift the status of author beyond material gains and gives it a special status, is responsible for the use of words special rights of authors. So, we understand the reason as to why do we call it special rights. This is a case in which Mannu Bhandari, who is a very famous reputed author, she has reputation in Hindi literature. She wrote a novel called as Aapka Bunty. That novel was a very successful novel. It is a prescribed reading in many universities. Many scholars have submitted their PhD work on critical analysis of this novel Aapka Bunty. So, this is a trend-setting novel written by Srimati Mannu Bhandari. The production house called as Kala Vikas Pictures Private Limited approached Mannu Bhandari to make a cinema basing on the novel Aapka Bunty, and they entered into a contract. The contract between Mannu Bhandari and Kala Vikas Pictures Private Limited says that Mannu Bhandari has agreed to allow the director of the cinema who is writing the screenplay to make certain changes in the novel so as to convert it into a successful cinema. She agrees to it. The contract also says that all the rights in the cinema shall be owned by the production house, Mrs. Kala Vikas Pictures Private Limited, and Mannu Bhandari will be left only with publication right. It also says that she will be given due credit on all the credentials, and when the film was released, she filed an objection that there are many alterations, there are many modifications, there are many deletions, there are many distortions, there are many mutilations, and therefore she is claiming that her right to integrity has been breached by Kala Vikas Pictures Private Limited. First point was they changed the name of the novel. The cinema is called Samay Ki Dhara, it is not called Aapka Bunty. I did not know about it. The production house is saying that she herself agreed to allow Mr. Sisir Mishra, the director, who was writing the screenplay, to make certain changes in the novel so as to convert that novel into a successful cinema. And now, after having agreed on this point, now she cannot go back. Now, the interesting observation of the court here is, she may have agreed to allow you to modify the novel so as to convert it into cinema. But all the assignment deeds, all the permissions which she may have given you will have to be read in the light of section 57. She may have allowed you to modify, but that power, that authority to modify will not include authority to distort. It was held that section 57 overrides the terms of the contract of assignment. Whatever you may have written in the contract of assignment, that has to be read in the light of section 57. No permission to modify would include permission to distort. And therefore, this is a very significant observation of Delhi High Court, that every contract of assignment would be read subject to provisions of section 57. So, every assignment of copyright is subject to 57. Even if the assignment says that I allow you to modify my work, that will not mean I allow you to mutilate my work. So, this is what happened in the case of Srimati Manu Bhandari versus Kala Vikas Pictures Private Limited. As I said, this was the first case on the subject of moral rights. And the two observations are, point number one, it elevates the status of author beyond material gains. That is the reason why we call these as authors' special rights. And second observation is, every contract of assignment has to be read in the light of section 57. Section 57 overrides any assignment deed. Another important judgment on moral rights is Amarnath Sehgal versus Union of India, 2005, Delhi High Court. Court says that moral rights are the soul of author's work. The author has a right to preserve, protect and nurture his creations through his moral rights. Let us understand how. Government entered into a contract with Amarnath Sehgal for renovation of the Vigyan Bhavan in Delhi, and for that purpose, Amarnath Sehgal agreed to create a mural to be installed in the front lobby of Vigyan Bhavan. It was a huge mural depicting India in true sense, and it was installed and it occupied its place of pride for many years. Somewhere in 1970s, government decided to remove it and consign it in its godown. Now, when government removed that mural, then Amarnath Sehgal wrote to various departments of government requesting them to reinstall the mural because it has become a national treasure and it is part of the cultural corpus of the country. It is such an important treasure that it must not be wasted the way government is wasting it. Or if government is not willing to keep it, government may return it to Amarnath Sehgal so that he may keep it preserved. Since he did not get any information from any office, he kept on writing, he ran from pillar to post, nothing happened. He kept on writing till 1991, and because nothing happened, then he was compelled to file a case of violation of moral right of integrity. Government opposed it, saying that it is time barred because timeline, the limitation to file a suit in Copyright Act is 3 years. But court said he kept on writing to you till 1991, so therefore he kept reviving the cause of action, and the limitation period of 3 years shall not be counted from 1970s, it will be counted from 1991. It goes. The second argument government took was that he has already assigned his copyright. Why? It was not actually the assignment. Government said that Amarnath Sehgal created this work under a commission job arrangement. And if you recall, we have discussed section 17. 17 says author is the first owner. However, there are many exceptions. One of the exceptions is that if author is creating something under commission job arrangement, he is only the author, he is not the owner of copyright. That is what government argued. It was a commission job arrangement, so therefore Amarnath Sehgal is not the owner. Whatever we do with the work which we own, he cannot stop us from doing that. But court says moral rights are not owned by owners, these are owned by authors, and therefore the argument goes. Court says when a work is created, 4 rights, in addition to economic rights, 4 rights come into existence. When a work is created, in addition to economic rights, 4 other rights come into existence. The first one is paternity right. We have it in section 57. Yes, we have it in section 57 expressly. I mentioned paternity right is also called as attribution right. It also includes right against false attribution. The second right is, according to Delhi High Court, the second right is divulgation right or dissemination right. Divulgation right is not an economic right, it is not there in section 14. And divulgation right is not expressly provided in section 57. So, publication right is neither an economic right nor an expressly recognized moral right. And if at all I have to place it in one of these 2 provisions, either 14 and 57, I will prefer to place it in 57 as one of the implied moral rights. Because there are many civil law countries which consider divulgation right or dissemination right or publication right to be a moral right. Delhi High Court says it is one of the rights with the coming into existence of work. So therefore, first right which comes into existence is paternity right, expressly recognized in section 57. The second right is divulgation right. Dissemination right may also be called as publication right, although it is not expressly recognized in 57. We may still accept it as one of the implied moral rights. We may consider it as one of the implied moral rights. The third right is integrity right or right to purity of the work. I already mentioned nobody can mutilate my work, distort my work to an extent that it harms my reputation. Again, this right is recognized in section 57. And the last right which he mentions, which he says it comes into existence, is right of retraction. Right of retraction means right to retract your work from market. It is the author who will decide whether I want to have the work in market or not. So he has the right to withdraw his work from market. This has not been recognized in section 57, it is not there expressly. Can we say that it is impliedly there? That is a question which needs to be answered. Now, there is an important point which I would like to mention. We have discussed the chapter of compulsory license, if you recall, section 31, capital A, section 32. There are few provisions of compulsory license. We got the permission to include compulsory license provision for foreign works. We have it in section 32, if you remember. Compulsory license can be issued for publishing translation of non-Indian works. That is allowed by Berne Convention, by way of Paris revision of Berne Convention 1972, with certain conditions. One of the condition is a country can have a compulsory licensing mechanism only as long as the compulsory licensing provision does not affect the moral rights. Now, if we read these 2, compulsory license and moral right of retraction, let us see what will happen. If I have a right of retraction, I will withdraw my work from market. And if I withdraw my work from market and a third person believes that this work is required in market in public interest, that third person can approach the commercial court, get a compulsory license, and I will be compelled to allow him to publish it again and bring it to market. You understand? You cannot have compulsory licensing and right of retraction together. You cannot have these 2 together. You can have only one. Because we already have compulsory licensing provision, which is there in section 32, can we have right of retraction? No. So, when Delhi High Court says 4 rights come into existence, the 4th right cannot come into existence in Indian context. So, we definitely have paternity right, we definitely have integrity right. We may argue that impliedly we can think of having moral right of divulgation or dissemination, but this right of retraction cannot be there in Indian law. Why? Because this is not consistent with the chapter of compulsory licensing. And Burns says any chapter of compulsory licensing can be there only as long as it is not violating moral rights. In this case, if we have moral rights of integrity, there will be inconsistency, and therefore we can have only one, because we have adopted to have compulsory license, we cannot have moral right of retraction. Coming to this case, government argued that we have not distorted the morale, we have only removed it from that place and kept it in the godown. Court said removal is the extreme form of distortion. It is an extreme form of mutilation. The final argument put forward by the government was, even if we accept that removal is extreme form of distortion, how will it harm the reputation of the author? How is it going to harm the reputation of the author? If somebody comes to Vigyan Bhavan and does not see a mural made by Amarnath Sehgal, how is it going to harm the reputation of Amarnath Sehgal? Now, here there are few observations which are important. Court says right of integrity ultimately contributes to the overall integrity of the cultural domain of a nation. If someone comes to Vigyan Bhavan, does not see the morale, there is no clear threat of harm to reputation, fine. But there is clear threat to a possibility of enhancement of reputation. Had it been there, people would have appreciated it and appreciated the artist. By the fact that it is not there, the possibility of enhancement of reputation also goes. This is as bad as harm to reputation. If we do not protect the cultural corpus of each artist, we will end up losing the cultural corpus of this country. So, moral rights can be used as a tool to protect the cultural corpus of individual authors, and that is how in longer run it can be used as a tool to protect the cultural corpus of this country. Court says through the telescope of section 57, it is possible to legally protect the cultural heritage of India through the moral rights of artists. It was also observed that destruction of a work being extreme form of mutilation, since by reducing the volume of author's creative corpus, it affects his reputation prejudicially, and this is actionable under this section. The case was decided in favor of Amarnath Sehgal, damages were paid, morale was handed over. What are the takes from this judgment? First point, there are 3 moral rights. We have discarded the possibility of having moral right of retraction. So, there are 3 moral rights. Second, moral right of integrity can be used as a tool to protect the cultural corpus of this country, because if we protect cultural corpus of individual author, only then eventually or ultimately we will protect the cultural corpus of the country as a whole. So, that is what I had to tell you about moral rights. Let it be very clear that there are 2 expressly recognized moral rights. There is one more moral right, you can argue that it is impliedly there because it has been recognized in Amarnath Sehgal. Right of retraction is not possible in Indian context. We understood the duration of protection, these rights are perpetual. There is one point which I will raise and leave it for you to decide. We discussed the chapter of offences in the previous lecture. Section 63 says, whoever knowingly infringes or abates in infringement of copyright or any other right conferred by this act is committing an offence. Any other right conferred by this act, will that also include moral rights of section 57? Can we file a criminal case in case of breach of moral rights of authors? Or do we only get civil remedies which are mentioned in section 57? You can have arguments from both sides. By the fact that I said 57 is the complete code on moral rights, there cannot be anything in the chapter of offences. On the other hand, One can also argue that section 63 says whoever knowingly infringes or abets an infringement of copyright or any other right, that will include any other right conferred by this act, including moral rights. So, we have arguments from both the sides where offences chapter is also relevant in case of moral rights or not. So, that is all on moral rights. Let us come to the next point which I wanted to discuss. This is called collective administration of copyright. If you recall, while discussing administration, while discussing assignment, I said that there are two methods of administration of copyright. One is individual administration, the other is collective administration. Individual administration is done under section 18 by assignment, under section 30 by license, and collective administration is a method by which various content creators, maybe lyricists, performers, singers, musicians, all the content creators will assign their rights to the copyright society, and copyright society will administer the rights collectively on their behalf. And copyright societies will work for the benefit of right holders. Try and understand, if I have to administer my rights individually, I cannot monitor the acts of infringement. There is a limit. How would I know that somebody is playing my song in a club in some other state? So, there is an extent up to which I can monitor acts of infringement, I can pursue infringers. But with the institutional capacity, copyright societies will be in a better position to follow and pursue the infringers and get the damages. So, for efficient management of rights, many content creators may agree to pool in their works, assign their works in favor of the society, and society will collectively administer those rights. What are the tasks performed by the society? Society grants licenses because it is a one-stop shop where all of us have assigned our rights and the license are granted by the society on behalf of all the right owners. Second, society will monitor these rights and pursue the infringers. Third, society will collect royalties. And fourth, society will distribute the royalties collected to the right holders. The idea of collective administration has evolved in different stages. It is a useful mechanism because now authors have the power of collective bargaining. Now authors have a mechanism to monitor the acts of infringement in a more efficient manner. I said it evolved in 4 different stages. The first stage at international level, the first stage is when different countries formed national societies. So, national copyright societies were made in different countries. This is the first stage of evolution. The second stage is when these national societies started entering into reciprocal agreements. So, an Indian copyright society enters into an agreement with a copyright society of England. You administer my rights in England, I will administer your rights in India. So, simply by joining this society, you get the benefit of 2 markets, Indian market and English market. Now, I can tell you that the society which works for music, Indian Performing Rights Society, IPRS, has reciprocal agreements with not less than 164 countries. That means simply by joining IPRS, you get the benefit of 164 markets. Now you have societies working in 164 countries and trying to get licenses arranged in relation to your works, trying to pursue infringers. So that is a very significant development in relation to copyright societies. So, first stage is when national societies were formed. Second stage is when these national societies started enter into reciprocal agreements. Third is when new societies started coming into existence for the benefit of new beneficiaries and new rights. In the year 1961, we came out with a convention called as Rome Convention. Rome Convention was for the protection of neighbouring rights. There are 3 beneficiaries of neighbouring rights internationally: performers, phonogram producers and broadcasters. We will talk about it later on in this lecture itself. Now, there are new beneficiaries coming up, so therefore, there is demand for new societies for these new beneficiaries. Plus, new rights were also emerging. In 1930s, there was a case in which public performance right was recognized. And when public performance right was recognized, a new society came into existence only for the purposes of administering one right called as public performance right. So, new societies were coming up for new beneficiaries, for new rights. And fourth is, with the technological development, new societies came into existence to deal with new uses of protected material. So, these are the four stages in which copyright societies have evolved. I said it is beneficial for both the creators as well as the users. The first point is it saves transaction cost. You don't have to, for example, if there is a radio station and it wants to play a song, it will have to enter into contract with number of right holders, lyricist, composer, performers, musicians. There will be n number of agreements, lot of transaction cost. You go to IPRS, enter into one document, get the song, play it throughout the day, you save the transaction cost. So, first benefit is it saves transaction cost. Second, it is an effective method of control. It is an effective method of control because societies have their offices at different places, they have manpower, they can pursue infringers, they can take matters to courts, which an individual author may not be able to do. Third, you get the benefit of the concept of collective bargaining. When an author, a lyricist, negotiates with the producer of the cinema, he is on the receiving end, he does not have the same bargaining power. So, an individual author is nothing in front of a producer, but when the society on behalf of authors is negotiating, it has the benefit of collective bargaining. Next, it is beneficial for users also. It is beneficial for users. Why? Because now users, the broadcasting stations, the radio stations don't have to approach many right holders. They will go to one place and IPRS or societies is a kind of one-stop shop for them. Pay the money, get the song, play it throughout the day. So, it is useful for users also. There is a very significant advantage of collective administration. Simply by joining one society, you get the benefit of large number of markets, as I mentioned, because of reciprocal agreements between the various national copyright societies. Now, Indian law on collective administration is contained in chapter 7. It says that it is mandatory for any person or association to get itself registered with the central government to carry on the business of issuing or granting license. So, for any copyright society, in order to come into existence, the society will have to get itself registered. And when it will apply for registration, there are certain factors which the central government will keep in mind. What are the factors? Interest of the owners of rights. The interest of right holders is to be considered. Second, the interest and convenience of the users. And third, ability and professional competence of the applicant. So, these are the factors which central government will consider before registering a copyright society. There are some interesting provisions. Ordinarily, one copyright society shall be registered for one class of works. So, there is statutory monopoly given to copyright society. For one class of works, you have one society. For literary works, you have IRRO, Indian Reprographic Rights Organization, one society. For music, you have one society, Indian Performing Rights Society, IPRS. This is there in section 33, subsection 3, proviso. And I said if you join a copyright society, the society will administer your rights, but that does not mean that you lose your right to administer your rights individually. Even after joining the society, you still have the authority to administer your rights individually. The only condition is that your individual administration must not be inconsistent with your obligation towards the society. So, individual administration is also possible. I will come to this administration, individual administration point again. Section 35 subsection 1 says, out of the entire money collected by the copyright society, the money has to be distributed, divided into distribution head and non-distribution head. Part of the money will be used in expenses of the society. Now, that division has to be done by getting approval of all the members of the society. Now, the money which comes under distribution head will be distributed to the members. And section 35 subsection 2 says that the royalty distribution to the members of copyright society shall be commensurate to the use of that work. The royalty distribution shall be commensurate to the use of that work. What is the extent of use of work of one individual? That will decide the extent of royalty he will receive. There is one provision which has been omitted now, section 34 capital A, this was omitted in 2012. It provided that an individual member is eligible to claim royalty only once his work crosses a threshold of circulation. So, for example, the society may say that you will be entitled to get money only once your work is sold more than 50 copies. Now, that was problematic, because if my work is sold, only 30 copies of my work are sold, I am not entitled to get any money. What will happen to that money? So, therefore, this section 34 capital A has been omitted. Chapter 7 also says there cannot be any discrimination between Indian work and non-Indian works. The reciprocal agreement provision is there in section 34 subsection 2. There are two provisions which are important. One is 33 subsection 4, the other is 33 subsection 5. Under section 33 subsection 4, a society can be suspended. Under section 33 subsection 5, registration of a society can be cancelled. And it happened once with IPRS. There was an inquiry pending against Indian Performing Rights Society, and there was a threat of suspension of Indian Performing Rights Society. I will not go in that. I said that despite being a member of Copyright Society, a member can still administer his rights individually. The only condition is that his individual administration must not be inconsistent with his obligation towards Copyright Society. So, individual administration simultaneously is also possible. But there is a proviso added, section 33 second proviso. This is important. This provision says that in case the work is included in cinematograph film, it has to be compulsorily administered through Copyright Society. Try and understand. I am a member of Copyright Society. Society is administering my rights. I can also grant licenses. But if the work in question is included in cinema, then in that case, I do not have a right to grant licenses, and it shall be granted only by the Copyright Society. Society will grant the license. So, there is mandatory collective administration for the works which are included in cinema. We will have to understand it in the light of a proviso which has been added in section 17. I mentioned it while discussing ownership. There is a proviso added in section 17 which says that, because 17 says author is the first owner, and then there are many exceptions. There are many instances where author does not become the first owner. For example, if I am doing something under contract of service, I am the author, I am not the owner. If I am doing something under contract of employment, I am only the author, not the owner. If I am creating something under a commission job arrangement, I am only the author, not the owner. But the last proviso of section 17 says, if the work in question is included in cinema, then proviso number B and C will not apply. That means, even if the work is created under commission job arrangement, author will become the first owner. And once author becomes the first owner, and author has already assigned his work to Copyright Society by virtue of the second proviso of section 33, now the work will be administered only by the Copyright Society. What I am trying to say, the combined effect of the second proviso of section 33 and the last proviso of section 17 is to reverse the decision of Indian Performing Rights Society versus Eastern India Motion Picture Association, in which the case was decided in favor of producer, where the author wrote lyrics under commission job arrangement and court decided that this work will belong to producer, and even for secondary uses of that work, author will not get any benefit. The whole situation has changed now. Now if the work is included in cinema, author is the first owner by virtue of last proviso of section 17, and when author is the first owner, it has to be compulsorily administered by copyright societies, whether as part of the cinema or whether in relation to secondary users. Author will always have a say through copyright society in getting the royalty. So this is an interesting part. The whole idea is to reverse the decision of IPRS versus Eastern India Motion Picture Association. So we discussed two parts. One is moral right, paternity, integrity, divulgation, that is sure. The second part is copyright societies, the collective administration. We discussed how it evolved in different stages at international level. What are the advantages of collective administration? A society will have to get itself registered with the central government. What are the factors to be taken into account? How to distribute the royalty? A society can be suspended, a society can be cancelled. And 2012 amendment made certain changes. The most important one is that in case the work is included in cinema, it has to be compulsorily administered through copyright societies. So there is mandatory collective administration for works which are included in cinema. There are few more changes. I don't want to go in detail of that. For example, I can tell you that after the amendment, all these societies have come under collective control of author and owner. Let's stop here on this point. Let us go on to the third aspect which I want to discuss briefly in next 10 minutes. This is neighbouring rights. We have to understand that concept of neighbouring rights emerged in the beginning of 20th century. There are three beneficiaries of neighbouring rights: performers, phonogram producers and broadcasters. You write the lyrics, I perform it, I am the performer, I am helping in the cause of dissemination of your work. There is a phonogram company, it will record the performance and it will spread it to a larger distance. There is a broadcaster who will put all the program on his signal and will transmit the signal to distant locations. So what we three of us, the performer, the phonogram producer and the broadcaster are doing, we are actually disseminating the work. We accept that we are not creating. We accept that we are not like authors, but we are the disseminators and we are helping in the cause of dissemination of copyright work. So these three beneficiaries started claiming protection within copyright system. It was opposed by the authors group, and therefore these three beneficiaries could not find protection within Berne Convention. In one of the revisions, it was decided that these three beneficiaries put together will be called as beneficiaries of neighbouring rights protection. People understood that neighbouring right will be a distinct category. The law of Austria of 1935 gave protection to these categories distinct from copyright, although the rights were quite similar to copyright. But they were not granted protection within copyright system. Eventually in the year 1961, Rome Convention came into existence and these three beneficiaries were granted protection. The terms were defined, the rights were identified, the instances of infringement were determined. So all that was completely done in the year 1961. Many changes have happened since that convention. For example, broadcasting was defined in 1961, keeping in view the only broadcasting which existed during that time, that is BBC. During early 70s, we realized that satellite broadcasting has also come into existence. So we had to modify the definition of broadcasting. In order to modify the definition of broadcasting, we came out with a closed convention called as Brussels Satellite Convention. During early 70s, we realized that record piracy is rampant on borders, on international borders. So therefore, in order to curb the menace of record piracy, we came out with a new convention called as Phonograms Convention of 1972. Subsequently, in TRIPS agreement, TRIPS refers to Berne for the purpose of protecting copyright, but TRIPS does not refer to Rome. I have already explained that referring to Rome would have meant referring to a convention which is tagged to obsolete technology. Phonogram has changed considerably from the stage when we used to play records, to cassettes, to CDs, to DVDs, to MP3, MP4, whatnot. So therefore, referring to Rome Convention would have meant that we are referring to a convention which is tagged to obsolete technology. Therefore, instead of referring to Rome, TRIPS agreement writes the rights and obligations again. So this is the historical development, international development of neighboring rights. It started in 1961. The three beneficiaries internationally recognized are the performer, the producer of sound recording, and the broadcasting organization. But let me tell you that in Indian law, sound recording is the subject matter of copyright. It is there in the list of section 13, if you recall. We give copyright protection to sound recording producers, and therefore there are only two beneficiaries of neighboring rights under Indian law. These are performers and broadcasters. These rights are similar to copyright, quite similar to copyright, but are not exactly copyright. I mentioned the conventions, if you recall. I said Rome Convention, Phonograms Convention, Satellite Convention, TRIPS Agreement, and then WIPO Internet Treaties. There are two treaties, one is for copyright, the other is for performance and phonograms. WIPO Performances and Phonograms Treaty. All these are the international documents on the subject of neighboring rights. Let us talk about the two beneficiaries, performers and broadcasters. The first is performers' rights. See, with the advent of printing press, authors started facing problems of unauthorized duplication. Same happened with performers with the invention of portable recording devices. Because once my performance is recorded, my performance gets detached from my personality. And therefore, you would not like to invite me for my performance because you have recorded it. So, with the invention of these portable recording devices, performers started claiming protection. In fact, International Labour Organization at one point of time said that these portable recording devices are creating problems for employment of performers. So, therefore, we got performers' rights protection. Section 2QQ defines a performer. Performer means it includes actors, singers, musicians, dancers, acrobats, jugglers, conjurers, snake charmers, a person delivering lecture, me. Now these are inclusive. The important thing is, or any other person who makes a performance. So who is a performer under section 2QQ? Any person who is making performance. So what is important is to define the word performance, and that is defined in section 2Q. Section 2Q defines performance. Performance in relation to performers' rights means any visual or acoustic presentation made live. Visual or acoustic presentation means it has to be either oral fixation, oral presentation, or visual presentation. So audio visual performance is not covered in the definition. A performance is a performance only if it is either oral or visual. So audio visual is not protected, and that is the reason why cinema artists are not considered as performers, and that is the reason we have a separate treaty called as Beijing Treaty, which is there to give protection to audio visual performances. That is beyond the scope of this definition of 2Q. Which is made live does not mean made in front of audience. Delhi High Court in the case of Neha Bhasin versus Anand Raj Anand says every performance in the first place is live. Before it is recorded, it was live. So therefore, every performance is live. That makes the definition as any visual or acoustic presentation. Audio visual performances are not protected. Section 38A talks about protection of economic rights. Rights in fixed performance includes reproduction right, distribution right, commercial rental right, and communication right. We know about the meaning of these rights. We have discussed it in section 14. In unfixed performance, there are two rights. One is right to fix the performance, and second is to broadcast or communicate the performance. Section 38B talks about moral rights of performers. It came in 2012 amendment. There are two moral rights: moral right of paternity and moral right of integrity. The last point in this discussion is protection for broadcasters. The right given to broadcasters is called broadcast reproduction right. It has got many rights. Section 2DD defines the term broadcast. Broadcast means any wired communication, any wireless communication, even rebroadcasting is broadcasting. I have identified two unsettled issues. One is regarding signal theft and the other is regarding regulation of webcasting. The rights which are there in section 37, and as I said, all these rights put together is called broadcast reproduction rights. This term broadcast reproduction right is a plural term. You have the right, these rights are right to rebroadcast the work, right to cause the broadcast to be heard or seen, right to make sound recording or visual recording, right to make reproduction of sound recording or visual recording, right to give the recording on commercial rental. All these rights put together is called broadcast reproduction rights. Broadcasters got delayed protection because we did not consider these as a fit subject matter for copyright, because broadcasting is not a thing, it is an action. So in the present session, we discussed three different concepts: moral rights, copyright societies and neighboring rights. We have covered all the important aspects of copyright law in these 7-8 sessions. From next lecture, we will start discussion on law of patents. That's all in copyright law. Thank you very much for joining. See you for the next session on patent law. Thank you very much.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.